Start. Ladies and gentlemen, this deliberations becomes increasingly relevant as the Indian government is likely to table India's fresh data protection law in the ongoing monsoon session of Parliament July 20 to August 11. Last date the government released the Digital Personal Data Protection Bill 2022 for public consultation. This is its third recent attempt at drafting a data protection law. While the draft released for public comments was not as comprehensive as its previous versions, news reports suggest that the government may present a bill that is largely similar. Considering this, critical gaps remain in the bill that would affect its implementation and overall success. In its scope and definition, the bill only protects personal data, that is, any data that has the potential to directly or indirectly identify an individual. In the modern data economy, use various types of data, including both personal and non-personal data, to target, profile, predict, and monitor users. Non-personal data is typically anonymous data that does not relate to a particular individual. For example, aggregate data on products which numerous users look at between. Often this non-personal data, when combined with other data sets, can help identify individuals and in this way become personal data, impacting user privacy. For instance, anonymous data sets about individual in New Delhi can be combined with prior timings to identify members who belong to a certain community, which could include their home addresses. This process of re-identification of non-personal data poses significant risk to privacy. Such risks were accounted for in previous versions of India's draft data protection bill in 2018 and 2019, but do not find a place in the latest draft. By not recognizing these risks, the bill is very limited in its scope and effect in providing meaningful privacy to Indians. A simple and effective solution, as in the earlier versions, would be to add a penal provision in the bill that provides for financial penalties on data processing for the re-identification of non-personal data into personal data. Another gap is the inability of the proposed data protection board to initiate a proceeding of its own accord. Under the bill, the board is the authority that is entrusted with enforcing the law. The board can only institute a proceeding for if someone affected makes a complaint to it or the government or a court directs it to do so. The only exception to this rule is when the board can take action on its own to enforce certain duties listed by the bill for users. Letter dated 5th March 1990 from the Hindustan Electrical Products Limited, Calcutta to Mrs. Suppu and Company, Howrah. Dear sirs, we acknowledge the receipt of your letter of the 3rd instant and thank you for the order for our table fans. We may inform you that we have booked this order in accordance with your instructions. As the varieties of fans that you have asked for are not in stock at present, we will try to forward them as soon as they are manufactured. In any event, we will be able to send them not later than the end of this month. In this connection, we would like to inform you that the fans will have usual guarantee for 2 years and we shall be prepared to replace them free of charge if any defect is found due to faulty material or constructions. We hope that this trial order will be quite satisfactory and will lead to an enduring connection with you. Yours faithfully.